Welcome back to the FITSNews studios, another edition of your Week in Review. A lot on tap this week, folks. We've got a corrupt judge who's been found unqualified and will be leaving the South Carolina bench soon. But as we reveal in this week's episode, not soon enough for victims of violent crimes. We're going to walk you through the very latest scandal involving outgoing judge Bentley Price. I'm also going to sit down with our research director, Jen Wood. We're going to update you on a big story that we covered a great deal last year, Death on the Tracks, the mysterious death of DJ Smith of Dorchester County, South Carolina. There's a civil suit which has put forward a theory of what may have happened to DJ. This is one of many true crime stories we're covering. You won't want to miss that update. And last but not least, I sat down with Dylan Nolan, our resident sharpshooter here at FITSNews, for an update on the gun debate at the South Carolina State House, particularly dueling battles over the Second Amendment and how to expand that liberty here in the Palmetto State. We're going to walk you through all that and more on your Week in Review. So why do I do what I do here? Why do we do what we do here at FITSNews? I don't want to speak for the whole team this morning. I want to speak for myself. I know why I do what I do. I was born in this state. I grew up in this state. Raising a family in this state, 7 kids, soon to be 8. And I know that there's a lot of folks out there like me who are worried about where our state is going. They're worried about their safety, about the status quo continually eroding that safety. They're worried about a system that's not fair, that's rigged, that works against them, even when the facts and the evidence and the law and the truth is on their side. So why I do what I do is because I believe that those institutions that we all pay taxes to support, that we're all obligated by their laws, by their rules, I believe those institutions should be fair, fundamentally fair. I don't believe that powerful people should be able to put their thumb on the scale and get a better outcome than they otherwise would have gotten, particularly an outcome that puts my kids and your kids at risk. Now, if you follow this news outlet, you know that we have made covering South Carolina's judicial system an area of emphasis, of focus. Started out with random reports we'd receive about judges granting questionable leniency on bonds or sentences. But over the years, it quickly turned into an epidemic, something that we started following much more intensely because it kept happening. And at the root of it, in more cases than not, were the powerful lawyer legislators who appoint these judges, who set their salaries, who set their office budgets, who can take them out of office anytime they want. Now, our media outlet has tried to shine a light on this process, the incestuous corruption, the undue influence. And we've been doing it for many years now. This past year, we finally saw an example of some accountability at work when one of the judges, I've called him the poster judge for excessive leniency for violent offenders, Bentley Price, lost his job. And it started last fall when Price was found unqualified by the South Carolina Bar. Now, the following month, there was a panel, the South Carolina Judicial Merit Selection Commission, which failed to vote him out. Now, it was a tie vote. It was 5-5, so that means there were 5 of these lawyer legislators that supported Bentley Price, but he was not advanced, and so he will be coming off the bench at the end of June this year. Now, that's significant because if you go through our media outlet, you will see story after story of Price letting violent offenders go free, of Price giving them incredibly weak sentences, and in several cases, of Price granting weak bonds, anemic bonds, at the behest of lawyer legislators coming into his court, including lawyer legislators who have bragged publicly about getting him his seat. Now, some of these lawyer legislators have been among the most vocal critics of our push for judicial reform, of our push to remove this undue influence. And it's interesting because we're going to tell you a story about Judge Bentley Price just this past week. Now, Bentley Price is on his way out. He will not be a judge, thank God, at the end of June of this year, which means the South Carolina Lowcountry will be a good bit safer with him off the bench. But before he goes, Bentley Price has been doing what Bentley Price does. And there was a case that came before his court just this past week involving an individual who's accused of multiple violent crimes against women. Now, if you followed our coverage, you remember Molly Vick. She came and sat in this studio and gave an impassioned interview about the injustice she endured in Bentley Price's courtroom as the individual who brutally attacked her and several other women was let go with a slap on the wrist. Well, guess what, folks? It's happening again. We're going to tell you the story today. There's pictures coming up on the screen right now. This is Walter Clayton Pate III, Charleston, South Carolina. He's an ex-Marine, but he was arrested last July on charges of assaulting a 19-year-old woman who was forced to receive treatment at the Medical University of South Carolina in the aftermath of this attack. She was bound by rope. She was handcuffed to a bed against her will, she said, and then sexually assaulted. Now, Pate is facing criminal sexual conduct in the first degree and kidnapping charges in connection with that attack. Now, while he was in prison, however, another woman stepped forward, his ex-fiancée, and according to her, he assaulted her as well, choked her, said, "I hope you die," punched her in the face. Now, this attack was actually captured on an audio recording, and there's a witness to it, Pate's former roommate. So he's now facing, in addition to the other charges, attempted murder charges in this case. And not only that, there are apparently sex videos that Pate made with this alleged victim, which he's held over her head, saying that he would release them and embarrass her if she ever left him. So this is the kind of individual we're dealing with. By the way, he's facing voyeurism charges in connection with those recordings. So a laundry list of charges, serious charges, attempted murder, kidnapping, criminal sexual conduct in the first degree. These are charges that can land you in jail for decades, and rightfully so, because they are violent crimes targeting women. So what does Bentley Price do? Grants Pate a consolidated bond in the amount of $40,000. Now, if you're familiar with the bond practices here in South Carolina, you know that's not a big number. And it's also, by the way, not a number Pate has to hit to get out. You generally raise about a tenth of it. You can post that as your surety and you're out the door. $40,000. 2 graphic assaults on women. You're probably wondering why. You hear something like that, you think, why? Well, obviously, the judge is on his way out. But would it surprise you to know, representing Pate in court on these charges, a lawyer legislator, Gil Gatch, is out of Dorchester County, and he is one of the most outspoken proponents of the failed status quo here in South Carolina. In fact, when we have taken to the airwaves to call for the removal of judges like Bentley Price, to call for the reform of this badly broken and corrupt system with this undue influence, it has been Gil Gatch who has been at the forefront of the pushback against us. And that's fine. I understand. He's entitled to his view. He's entitled to believe that this system, which rewards habitually violent offenders, including Pate, who attacked these 2 women, according to police, he's entitled to defend those people. But you know what he's not entitled to? A rigged system. He's not entitled to walk into a courtroom knowing that he's going to be able to get an outcome like he got in this case from Bentley Price. Now, again, Bentley Price is on his way out. Again, thank God. But there are many more judges in South Carolina who too often allow this influence to corrode their decisions, to impact their decisions. And I want to point out here, we've called Price out, and our reporting is, in many ways, one of the things that led to him being found unqualified to continue serving. But it's not always the judge's fault. Price, I believe, is a case where it clearly is, but in a lot of cases, these judges, I couldn't imagine that kind of pressure. Standing in front of someone you know can take you out of office? How do you make a fair decision in that case? How can you honestly weigh and assess the facts of those cases, knowing that, again, one of the lawyers standing before you can have you removed? Well, folks, this week, for the first time, the South Carolina Senate took up the issue of judicial selection reform. I was at the meeting, sat through the whole meeting, and it comes on the heels of the South Carolina House convening a panel to study the issue as well. Now, unfortunately, neither the House nor the Senate are proposing anything resembling substantive change. They're tinkering around the edges of the selection process, which, frankly, I don't think is going to do enough. But here's the thing, and I want to be clear as I've talked to my friends in the legislature, many of whom I know are watching this. At the end of the day, I don't care what the systemic change is. I don't care specifically what the reform is. What I care about are that the outcomes change, are that when you or I walk into a South Carolina courtroom, that we know the facts of our cases are going to be fairly heard, and that lawyer legislators will not be able to improperly influence those decisions. And I want to be very clear here. We are talking about violent crimes. We are talking about crimes that destroy lives, take lives, destroy families, and leave a trail of victims in their wake. And in fact, this week, we sat down with another of the many victims of our justice system here in South Carolina, someone who lost a family member in a graphic way and had a powerful lawyer legislator manipulate the system to get an unjust bond for the man accused of murdering her relative. Laurie Williams sat down with us this week to talk about the murder of her brother, Larry Vaughn, about the unjust process that has unfolded in the aftermath as his accused killer, Evan Hawthorne, a former law enforcement officer, was let free on a controversial bond after a lawyer legislator intervened in the process. Here's an excerpt from my conversation with Laurie.
And the bad thing about it is they have always said it's the good old Southern way, you know, the good old, what is it, the good old boy system or something like that. But everybody used to always deny that. And that was like, it's happening out in the open. They don't try to hide it anymore, you know, and it's not a fact of who's the better lawyer or this, that, and other. It's who's the cheater. I mean, you're not lawyering any better than the next one. You're just doing some underhanded stuff. And then having the power, you know, the power to conceal it. You know, so not everybody, I mean, you know, not everybody knows the ways to go about finding things out. You know, and who's going to talk to me? You know, and who's going to be honest with me? Or who's just going to blow smoke up me to quiet me down or satisfy whatever my question was, and we're going to go on to the next. And are we really going to take into account what this lady just said, what happened to her? You know, is it going to take, God forbid, something like what happened to my family happening to one of those legislators' families, to where they stand before a committee and they get brushed off like they don't matter? And it's not public. I mean, it's not public perception. I'm here. My feet are in the muck. You know, I'm not making it up. I'm telling you what happened. I saw it with my own eyes. I'm not the only one. There's plenty of people that see it. There's plenty of people that are standing beside me and behind me that are victimized too. But do they care? I think in some of their hearts they do, and they want to make a difference. But are we really going to fix the problem? I don't know. I don't see it happening. I mean, but hope. Hope. I mean, Toby Keith said it the other day on his interview before he died. It's like, how do you get through all this terrible stuff? Faith. You have to have, I have to have faith in a system that my brother protected for 30 years. But I'm losing that faith. You know, I have faith in my God. I know my brother will get justice one day because he's going to get the ultimate justice, you know? But we can't just keep victimizing victims over and over and over and making us feel like we have no recourse. We put these people in these positions, you know? We can take them out of them, you know, but we got to make a big enough ruckus and have enough people to know about it. And that's just it. You know, we send them to Columbia. Do we check behind them? Honestly, I didn't, you know, but there's got to be some accountability and there's got to be some kind of consequence. You know, if I did wrong, I would definitely suffer a consequence, you know? But it's like, you know, how many times do you do something from the bench or from the attorney's table? How many times do you get to be crooked and never get a slap on the wrist or never lose your position? It's just like they know there's not going to be a consequence, so they just have free reign over Columbia. And that's not right for the citizens of South Carolina. Whether you're a victim or not, one day you will be a victim. Maybe, hopefully not a crime victim, but you'll be a victim of something that they've done that could have been done different.
Folks, I can't say it any better than that. And that is why this media outlet will always fight for the integrity, the independence, and the fundamental fairness of a justice system that we all need to rely on. Count on this media outlet to continue that fight, no matter what. So many of you who follow our true crime coverage came here for the Murdochs, but over the past few years, we've been covering any number of high-profile cases here in the Palmetto State that are just as complicated, just as intricate, and just as unresolved. And one of those cases involves a mysterious death back in 2018 in Dorchester County, South Carolina. We have covered the story of Daniel Reed DJ Smith on our media outlet. Jen Wood, you wrote the first story about it, and from that story there was so much interest and so many questions that we actually did several episodes of our Fitz Files podcast on the story of DJ Smith. Jen, for those who haven't dove into this story yet, give us the background on the disappearance and death of DJ Smith back in 2018.
So DJ Smith was a young man. He was found on the railroad tracks in a remote section of the railroad tracks on August 11th, 2018, the afternoon. His parents reached out to me, I think, during the Murdoch trial and asked me to take a look at the case. And it was fascinating because his stepdad, Eric, he used to be an investigator with the First Circuit Solicitor's Office. And he had law enforcement experience. And the initial investigation started with Dorchester County Sheriff's Office. So they began the investigation and did the, the coroner came and talked to them, indicated in their initial conversations with DJ's parents that the death it wasn't an accident. It wasn't him being hit by the train. So, that was the initial indication. And then, as the investigation went on, it was transferred over to SLED due to a conflict of interest because Eric worked with the solicitor's office. So, as the investigation went on, Eric and Lisa, they started getting indications that they were going to close the investigation, call it an accident. DJ was walking on the train tracks and got hit by a train. So Eric got all of the files, all of the interviews, and started listening to them and looking at all of these files, and things did not add up. So DJ had been at a party the night before his body was found with a number of friends, and the stories were just wholly inconsistent from the last people to have seen DJ. It was one person said there was a fight. One person said DJ woke up mad and just left the house and walked away. So the inconsistency in the stories was the first red flag for Eric as an investigator. So he continued to pursue, answers. And, in the course of reviewing the file with him, we looked at the autopsy report, and the injuries did not make sense to us. So we asked a doctor who used to be a trauma physician to review the autopsy, review the crime scene photos. And she said immediately, this is not a train accident. He's got tire treads on his pants. The injuries, if it were him getting hit by a train going 45 miles an hour, the injuries would have been far more catastrophic than they already were. So, we realized that, Eric, who is a really good investigator, had some very good points. They connected with an attorney out of Columbia, Tucker Player, who saw the whole case file. He saw the same things we were seeing, saw the same things Eric was seeing, and said, this is not a murder, or this is not an accident, this is a murder, and agreed to take on the case to see if he can get answers through a civil filing.
Now, you and Tucker Player, along with our Dylan Nolan, Andy Fancher, you guys have actually been down to near Ridgeland, South Carolina, to that remote part of the railroad tracks where DJ's body was found. Jen, just before we go into the Tucker Player component and the wrongful death suit that we're going to talk about, just tell us real quick about that trip and what you saw.
So, when I say remote, I mean remote. These train tracks are, in a section bordered by woods, bordered by hunting land. There's steep embankments. And, when we were looking at the case, we all agreed that to really get an understanding of the probability of him being hit by a train, we had to go see where his body was found. So we drove out there, we climbed those steep embankments, we walked up and down the tracks, and it just made absolutely no sense, from the timing that he left the house to the time that the train went through, to how his belongings were found in relation to his body. None of it made any sense. And, it's so remote that, while we were out there, we all agreed somebody went to a lot of work to get his body where it was. And
Absolutely.
yeah, there's more questions than answers right now, but I think it's safe to say that he was not killed by a train hitting his body.
Indeed, and that's also consistent with the findings of that forensic report that we were provided with. It clearly indicated that he did not die where his body was found, that his body was placed there. Jen, let's walk through this wrongful death lawsuit. It was filed just this week, and we do want to point out this lawsuit names several individuals, including 3 unnamed individuals, 6 named individuals, 3 unnamed individuals. But obviously, these are not criminal charges. These folks are not accused of committing any crime, but they have been named civilly in a wrongful death case. But that case does put forward, Jen, a theory as to what may have happened on the night that DJ died. Walk us through this wrongful death complaint.
So when I first met DJ's parents, Lisa and Eric Melendez, Lisa was very open with me that DJ had struggled with drug addiction. And, I think she was worried that because of that addiction, they weren't taking his death seriously. So the theories that we've seen the last night that DJ was alive and he was at this party in Dorchester County, they align with possibly a drug deal gone bad or a fight over a girl, believe it or not. We had heard some of the party attendees had said that there was a fight Some said there wasn't a fight. But the theory that Tucker put forward in his filing was that there was a fight. DJ left on foot and he was chased down and run over by a vehicle, which, given the evidence of tire tracks on his clothing and his injuries, makes a lot more sense. And then after that happened, they coordinated with individuals to get his body to that point on the tracks.
And Jen, it's important to point out, obviously, in a civil trial, the standard very different from a criminal proceeding. In the criminal proceeding, individuals must be proven guilty beyond a reasonable doubt. That's a very high standard. Obviously, we learned a lot about that during Murdoch. We try to educate our readers on these standards. But on the civil side, the standard to be found guilty or to be found a judgment entered against you in a civil case, wrongful death, it's different, isn't it?
Yeah, it's so where criminal, like you said, beyond a reasonable doubt. In a civil case, they only need to demonstrate a preponderance of evidence to the jury. So it's a much different standard. But I think really the Melendez family, they're just looking for answers. They just want to know what happened to their son the night he died, and for the people involved to be held accountable. So it's an interesting case because I think the primary goal of this is to get subpoena power, depose these individuals, figure out what happened that night.
To get the answers that were not uncovered by that law enforcement investigation. Absolutely. And I enjoyed, Jen, your excellent reporting on this on FITSNews. Just a wonderful, wonderful work on that. And also appreciated you had Lisa in there at the very end talking about this is not about money for her at all. She just wants those answers. Sensational work, Jen. By the way, if you haven't caught up on this case, Fitz Files, our podcast, you can check it out. Death on the Tracks. There are multiple episodes, or just go to FITSNews.com and type in Death on the Tracks. And you can get all the articles, all the research, all the reports on the story of Daniel Reed, DJ Smith. But this is, again, Jen, one of many stories we are covering. It's not all Murdoch here at FITSNews. There are multiple cases that we are covering. We've got the horrific Green Pond massacre in Colleton County. If you think the Murdoch murders were brutal, the Green Pond massacre is by far and away the most graphic, disturbing, horrific crime that I've ever seen in my years as a journalist. Certainly that we have covered here at FITSNews. We're covering that. We've also got a quadruple homicide up in Anderson County, South Carolina, that's beginning to make its way through the court system after some recent arrests of a husband and wife in connection with that quadruple homicide. But then we've also got a story that was on Fitz Files as well, Jen, the Rose Petal murder. And this week up in Greenville, South Carolina, there were some developments in that case. If you followed this story, you know that charges have been filed, murder charges against a concert pianist, Zach Hughes, who had, at the time of the murder, no known relationship whatsoever to the victim, a vet tech named Christina Parcell. But as this investigation has unfolded, Hughes has been linked now criminally to the ex-boyfriend of the victim, a gentleman by the name of John Mello. Mello appeared in court this week, and our Andy Fancher was there. Let's cut to Andy's report on the latest on the Rose Petal murder.
Good afternoon, folks. Andrew Fancher with FITSNews.com. Standing here in Greenville, South Carolina, following the preliminary hearing of John Mello, the estranged ex-boyfriend of murder victim Christina Parcell. For those who recall, Parcell was stabbed in her sister's house 31 times before her body was dragged into the living room and sprinkled with dead-headed roses, entitling this crime the Rose Petal murder. And while concert pianist Zachary Hughes was indicted with Parcell's murder in September of 2021, Hughes was indicted again in 2023, but this time alongside Mello with criminal conspiracy and first-degree harassment. This gave some indication to the public that Greenville County's detectives were working to connect Mello to Parcell's murder. Come this Thursday, Magistrate Judge Matthew Hubbard held a preliminary hearing to determine if there is enough evidence for the case against Mello to move forward. During the hearing, we heard from the affiant of these arrest warrants, who attested to viewing hundreds of Parcells' nude photographs supposedly shared by Hughes and Mello prior to her death. While the defense argued that Parcells' nudes were uploaded online at the victim's consent, Judge Hubbard determined the existence of enough probable cause for the state to move forward with their case. Afterwards, Solicitor Walt Wilkins told FITSNews that Mello's custodial interference trial is tentatively set for next month, while the state's trial against Hughes is expected in 6 to 7. So keep in tune to FITSNews.com for the very latest on this intricate and incestuous case.
Jen, where is this case going?
It's anybody's guess. I think the trial for John Mello's custodial interference looks to be tentatively scheduled for next month. So that's definitely going to be something to watch. And Solicitor Walt Wilkins also gave us indication that the charges related to Christina Parcells' murder is going to be scheduled in 6 to 7 months. So we should see some movement in all of these cases finally.
Yeah, just a horrific story. Christina Parcells stabbed more than 30 times about the head and neck area, ritualistically posed in the living room of her sister's home in Greer, South Carolina back in October of 2021. Just a truly horrific crime. But again, as we reported back at the time, layers to this story. She was involved in some activity that makes her, again, not quite the sympathetic victim that some would portray, given some of the allegations against her and the boyfriend at the time of her death, Bradley Post, who has been charged with multiple crimes related to child porn, bestiality, just some horrific stuff there that's going to make this an incredibly layered story. But once again, if you came to FITSNews for the Murdochs, know that we are covering a ton of other just truly in-depth, layered true crime stories. So keep it tuned right here, FITSNews.com, for the latest on all those stories. So if you own a firearm in South Carolina or have plans to own a firearm, you might want to pay attention to this segment. There is a major Second Amendment debate brewing at the South Carolina State House, one involving multiple gun rights groups that are not exactly on the same page on this issue. I am joined by Dylan Nolan, our Director of Special Projects, producer of this program. Dylan, you've been following this debate as it has been moving back and forth between the legislative chambers. What's going on in South Carolina? First of all, let me start with this question. Why does the state of South Carolina need to pass a bill for a right that should already be enshrined in our Constitution?
Well, I'm not one to say what we need to or don't need to do, but I can certainly explain to you what advocates for the bill are saying. And constitutional carry is a legal framework that's been passed in 27 states. If you were to look at a map of America, it's the 27 conservative states, I would say, plus a couple that are kind of on the fence.
You've got that map in your story on FITSNews.
I do, yeah. South Carolina, North Carolina, I believe Virginia also aren't on that list yet. However, there's movement. And basically what this is an enshrinement of the Second Amendment as it is construed by a lot of conservative gun owners into state law. And what that means is that if you're in any of these states, barring the ones that say you have to be a resident, you can carry with you a concealed, or in many places, open carry handgun, long gun, without going through a concealed weapons permit process.
Takes the government regulation out of gun ownership.
Right.
But it's controversial. It's been something that there have been debates back and forth between different factions of the Republican Party, different gun rights groups. Walk us through how this debate's been evolving at the State House.
Well, I think first, before we look at the debate within their Republican Party, I think it's important to say that there are also a lot of people who broadly think that this is a dumb idea, on the political left. South Carolina, I believe, is number 8 in America as far as gun deaths go. Now, if you look at that, the majority of those are suicides, so you can obviously say that a bill that lets you carry your gun in a wider number of places probably isn't going to affect the amount of people that kill themselves. But the rest of those are homicides. So I do think that there is a valid point to be made that if there's a lot more people walking around strapped, the odds that more people are going to engage in shootouts is higher.
But Dylan, isn't the counter argument to that if we have more people walking around strapped, some of these mass shootings might not be as deadly because people could take the shooter out sooner?
You know, it's interesting. I've lived in the North, I've lived in the South, and they say an armed society is a polite society. And I definitely think that there is some merit to that. I just have personally seen that the instances of petty crime, whether, that be you getting punched in the street and mugged and robbed, if you don't know that the person that you're about to do that to might shoot you, you're going to think twice. And I do feel more confident walking around, cities in South Carolina at night. Obviously, there's neighborhoods you don't want to go, just like there are in every city. So I definitely understand that. The argument for mass shootings, I think, is a little bit more complicated because almost every one of these mass shootings happens in a place where law-abiding citizens are forbidden, and even under this new bill would still be forbidden from carrying a handgun. What's interesting is that lawmakers in South Carolina have made some of these places where you're prohibited from carrying a handgun only a trespassing charge if you choose to break the law and still carry a gun. And I like that because it means that if you're a real cowboy, you could still walk into a lot of these places where mass shooters think that they can get away with blowing a lot of people away scot-free if you're willing to take the risk of getting a charge.
So we're talking about, obviously, different places that you're allowed to carry, different classes of folks that are allowed to carry. I wanted to ask you a question. You and I talked about this week as you were covering this issue. And by the way, you've got an amazing article up on FITSNews. I know we showed that graph earlier, but great coverage of all of the details of this bill. But I wanted to ask you this. We talked about violent crime in South Carolina. It's been on the way up. Gun crimes have been on the way up. But as we talk to local law enforcement, as we talk to state law enforcement, as we talk to prosecutors in these various areas where crime is soaring, they tell us it's really tied to a handful, a few dozen folks in each of these areas, and that if we can just get stronger felon in possession laws on the books, that would take care of a lot of the problems that folks are using as kind of a red herring on this bill. Where are you on this felon possession thing? Or let me ask it differently. Where is this bill going as it relates to felon in possession?
Yeah, so you might be like, okay, you guys were just talking about a bill that lets you carry guns in more places, and then now you're talking about a completely separate legislative matter, which is felon in possession. The part of that you left out is that law enforcement vehemently opposes this bill. It makes it a lot harder for them to do their job because if all of a sudden everybody is presumed to be legally allowed to be walking around with a handgun, they can no longer, in the course of routine arrests, slap people with criminal charges for possessing a handgun without getting a CWP. The reality is that a lot of these people who are inclined to commit crimes don't go get CWPs. And that's not shocking. I just was at a CWP class myself. It did not look like a group of people who are going to be holding up a liquor store anytime soon. But these felon in possession laws are something that typically is enforced at the federal level. And during the presidency of Donald J. Trump, there were Republican U.S. attorneys. Yeah. And now that we have Joe Biden in the Oval Office, he's appointed Adair Ford Barrows. You might remember her from her 2020 run for Joe Wilson's congressional seat, which she, of course, lost. There was no chance in hell that she was ever going to win that seat. But that's something that you run for so that when there's a Democrat in the White House, they appoint you U.S. attorney. So, she played the game and now she's getting her reward. Well, the downside is she's not aggressively pursuing these felon in possession charges. So now the state level law enforcement guys are like, oh crap, we got a lot of felons running around with guns. And so basically their agreement with the legislature, which I would say that the state law enforcement lobby has far too much control over what the legislature does. The legislature is there to represent the people, not to represent Mark Keel. And you can tell this, you can see that they have too much of a hold by looking at polling of how people feel about medical marijuana passage, and then looking at the fact that it consistently gets held up by the law enforcement lobby, in spite of the fact that the vast majority of South Carolinians would like that to be law.
You think the same thing's happening here with felon in possession?
Well, they certainly got what they wanted, which is, in addition, basically gives them the ability to enforce this law that the feds have slacked on enforcing. Mm-hmm. And I don't think it's a bad thing. I think if you're somebody who's a violent criminal who's proven that by being convicted of being a violent criminal, you certainly have no right to be walking around carrying a gun, carrying ammunition. You forfeited that right.
And so the mandatory minimums imposed by this law, 5 years on a second offense, 10 years, I believe, on a third offense. But in drawing that statute, have lawmakers not erred in terms of overly classifying these felons? For example, nonviolent felonies. You could have, not robbing liquor stores, not
Right.
no crimes involving firearm. You could be banned or imprisoned if you do go out and buy one.
So that was my concern when I initially read this bill, and I know you and I talked about this. So I was like, well, this seems kind of crazy. If you commit tax fraud, if you are a white collar criminal committing a felony above the shoulders, so to speak, I don't have a problem with you walking around strapped after that. After you pay your time, you go to jail, do your restitution, sure, you should be able to have a gun. Turns out that there was some pretty complex language included at the end of the statute, which carves out these people. So really, it is truly only violent felons. And to me, okay, if you're going to make these carve-outs for these people who didn't commit the kind of crimes that are a real danger to society, I'm okay with it.
Now, there's also an amendment, and we're talking about all these amendments to the bill. Let's talk about the amendment that allows lawmakers to carry guns wherever they want, a different standard for them than obviously the rest of us. Tell us about that.
Yeah, this is
component.
something that the Freedom Caucus guys were really upset about. They sent an email out. They had a post on their Substack, which, by the way, that's a really interesting way of communicating with constituents that I think that more legislative groups should try. I think that the Freedom Caucus's direct approach of addressing their constituents is definitely very effective. But if you look at the current South Carolina law, magistrates, assistant attorneys general, a bunch of these law enforcement, quasi-law enforcement personnel who aren't included in other places in the statute as far as giving them exceptions to the gun laws, but people whose lives might be at an elevated danger due to the job they do for the state are included. The legislators wanted to add themselves to that list. I believe Gerald Malloy proposed that amendment and the Senate adopted it. Quite frankly, I don't care. Now, obviously, the rules for thee, not for me, that's a good tagline, and I can understand why people might be upset about it, but I'm kind of a brass tacks guy, and at the end of the day, I don't think that legislators carrying or not carrying a gun is going to do very much to increase or decrease the public safety or constitutional rights of South Carolinians.
They got to be sober enough to aim it, right?
Yeah, well, that's going to be the challenge for most of them, and hopefully this exemption does not exempt them from the need to be sober while using their guns.
Well, let's ask about this bill, though. It's out of the Senate now.
Right.
It originated in the House. The House passed a version of it. It went to the Senate. The Senate amended it significantly on multiple different facets. It's now back over to the House. So the debate last week was whether or not the House would accept the Senate's changes, basically vote to concur. At that point, it would have gone to Governor McMaster for his signature. But the House had some back and forth on that, didn't they, Dylan? It was not...
Well, you posited that the Senate amended it significantly. And I don't know that that's something that you can presuppose.
Okay.
So the Senate's amendments, we got the legislators can walk around strapped. We've got one that says that SLED has to pay for training, a free training, basically make it available for all South Carolinians. Mm-hmm. That's something that I think is a good idea, but also if you're a small government person, I don't really know how you can, in good conscience, argue for adding to the financial burden of SLED, and I think that's an argument that a lot of people in the House were making. And then the one that I think really upset a lot of people is basically they turned this from what would fit into the constitutional carry framework that we've seen across the country into something that is definitionally not constitutional carry. And this amendment adds criminal penalties to people who commit violent crimes without a CWP. Now, I smile as I'm saying this because I was going through this bill and going through the current statute line by line just to see what exactly was going on here. And I read this amendment, and I'm just like, what in God's name? You're going to give people an elevated penalty if they commit a violent crime without a CWP? Who cares whether you have a CWP or not if you're holding up a liquor store? Mm-hmm. And then if you look a couple lines down, it says that all these gun retailers in South Carolina are going to have to give you a sheet of paper that says, if you don't get a CWP and you commit a crime with a gun, you will have an elevated sentence. So this, I believe, is a concession to the group of senators who, throughout this whole amendment process, were trying to get basically a two-tiered system put in, which is, of course, not constitutional carry. Now, I can understand why you might think this is a good idea. I could, folks who go get a CWP, they've exhibited a level of training that, and a level of knowledge of the law that I could see being beneficial. I just went and took the class. As somebody who's fairly familiar with South Carolina gun law and familiar with how to safely operate a handgun and familiar with basic gun safety, nothing in there was shocking. I got 100 on the shooting test. I got 100 on the written test. So it's not...
I think we need to see some proof of this, Dylan.
Oh,
yeah, you've been waiting to whip this thing out. Let's whip this thing out.
And
come on.
I think there are a couple shots that weren't perfect, but it's pretty... that's
you
pretty
go.
solid, people.
Look at that.
I'm happy with it.
Hell yeah.
But my point is here with this dual class. This was something that was ultimately unacceptable to the true constitutional carry people, because at that point you still have a permitting process that is essential to being able to exercise your right to carry a gun. If you say you can carry a gun without a permit in the public roadways, but if you want to carry it into a place of business, you're going to need a CWP. Well, it's not constitutional carry. And that ended up getting shot down in the Senate. But I think that this amendment was introduced because there was a lot of these senators who said, look, I'm not going to lend my support to the bill unless some version of that system is implemented. So as asinine as it is to have an amendment which says, okay, if you commit an armed robbery with the CWP, you're not going to get an uptick in your sentence, I think that this was necessary to get it to go out of the Senate. And I think that this was this, but also it doesn't really matter to you if you're a South Carolinian who's planning on legally owning your gun, whether or not you're going to get a sentence enhancement for not having a CWP.
That would almost mean like you have to be planning to rob a liquor store, planning to engage in some sort of violent activity with your gun before you go get the
I had
training.
a text loaded up to a senator that I ended up thinking better of sending, but it was, well, I'm really glad that you guys got that amendment in there because I was planning on robbing a liquor store and I'm about to get my CWP card in the mail. It's just how ridiculous that amendment is. Now, some folks, now you said, okay, you posited that these were substantive amendments. I don't know. To me, if that's what it needs to get through the Senate and get passed into law, I don't know that that's enough to need to pull the brakes on the whole bill.
Well, let's discuss the process. Substantive or not, we'll let the folks that watch this.
Yeah, you guys at home can decide. We're not here to tell you how to think. We're just trying to tell you what's going on.
Substantive or not, the legislation that came out of the Senate is different than the legislation that the House sent to the Senate. So therefore, the House has one of two options. They can concur with the Senate bill, in which case it would then go to Governor McMaster, Henry McMaster, for his signature veto, or he can technically not sign it and stick it in the desk for 10 days, then it becomes law. But they didn't do that, did they, Dylan? In fact, there was a lot of back and forth in the House about how they should respond to the Senate amending the bill and sending it back. So walk us through this sort of crazy day in the House as the Senate changes their bill, throws it back in their lap. Walk us through what happened.
So yesterday, I'm trying to write an article about this bill coming up before the House. And the question is, the whole day, and this is what I'm working back channel sources trying to figure out, is the House going to pass the bill as amended by the Senate and just concur and send it straight to McMaster's desk, or are they going to take up amendments? And there are a number of representatives who said, no, this isn't constitutional carry. We need to have this thing amended. But it seemed as though House leadership wanted to pass the bill as the Senate amended because they were operating under the assumption that the Senate is not going to remove any of these amendments. As stupid as the one that we just discussed is, it seems as though removing it is a non-starter in that body. So the House leadership got the backing of the National Rifle Association, obviously our country's largest gun lobby, but one that in recent years has been embattled as they've had financial fraud and they've had a bunch of members dropping off. And they've even, they stood with Donald Trump when he was banning bump stocks. I don't know too many gun owners who like their gun lobby to actively participate in the reduction of the rights of gun owners. And so that's opened the door for a number of more hardcore, no compromise type of organizations to crop up. And sure enough, these organizations were sending out text messages to constituents, which were resulting in them calling and emailing and texting their representatives saying, don't pass this thing with these stupid amendments in there. And over the span of a couple of hours, and by the way, I would like to give credit, if people are wondering what this organization is, the National Association of Gun Rights, I believe, was the one that was leading the charge. So if you think that, they should have compromised and this kills the bill, well, you can go blame the National Association for Gun Rights. If you think, man, this stupid compromise, screw the senators, let them vote no in an election year, then you can say, blame the NRA. But it really did end up being a rumble between these two advocacy groups. And House leadership seems to have turned on a dime. Now, were they trying to drive the bus and whip the votes, for the NRA, whip the votes for we don't want to hear your amendments, or were they actually going to their members and saying, how do you feel about this? I don't know. It depends who you talk to in the conference. But that's the situation. And by the end of the day yesterday, the House, which started out the day looking like it was going to stand with the NRA, and just send the bill right to McMaster's desk and effectively make South Carolina the 28th state with constitutional carry, albeit with some definitely stupid amendments coming out of the Senate. But, that's nothing new for the South Carolina Senate. Now this goes to a conference committee. And so this will give the opportunity for those people in the Senate who have been dragging their feet, the same people who dragged their feet in 2021, to have another bite at the apple of killing this legislation. So if this never makes it out of conference committee, I think that this will have been a bad gambit on the part of the people who, wanted an absolute no compromise bill. But who knows? They could get what they want. They could get some of these bad amendments removed.
As you mentioned, it is an election year. Those senators who vote against a pure constitutional carry bill are clearly going to be in the crosshairs electorally. Certainly it's an issue, as you mentioned, these grassroots gun groups as well here in South Carolina exercising tremendous influence over the process. And so, but it's such a confusing issue. We sat here and we talked about all these amendments, and when these votes go back and forth, the votes on amendments, then votes to pass the bill. Now we've got a conference committee that's going to produce a new version of the legislation. That's going to have to go back through both chambers. So these lawmakers are going to ultimately end up taking a bunch of different votes on this issue. And as well as I do in campaigns, people can cherry pick one of those votes and blast it out in a mailer, blast it out in a text thread, and all of a sudden you're explaining. And as you know, Dylan, in this business, if you're explaining, you're losing. Let me ask you this question. You follow a lot of these issues that make their way through the legislature, and then you also follow a lot of the campaigns. We're heading into primary season. Filing starts in March. Primary elections are in June. Where do you see the Second Amendment and this debate over constitutional carry? Where do you see that stacking up as one of the hot button issues? Do you think it's going to be very significant in these races? Not so significant? How do you think it's going to impact them?
I don't know that it's something that is on the tip of every voter's tongue, but I do think it's the kind of thing that a campaign could send out mailers and really blast a House representative or a senator who's on the wrong side of things.
Absolutely. Well, Dylan, a little over 2 years ago, you were getting ready to go to business school, or you're out of business school, getting ready to go work in the accounting industry. You are now, again, driving this coverage, the most in-depth coverage of this bill, interviewing each of the lawmakers that are involved in this. Credit to you for your work on this. Great reporting. Keep us posted on this as it makes its way through the legislature.
Will do.
All right, folks, that's a wrap for this week's edition of Your Week in Review. Be sure to tune in next week. We're going to dig into the first in the South presidential primary and try and figure out whether all those Democrats saying they're going to cross over and vote for Nikki Haley here in South Carolina, will they have an impact? Could she get close to former U.S. President Donald Trump here in the Palmetto State? We're going to dig into that next week. But thank you for watching. Thanks for tuning in. By the way, if you haven't already, please please subscribe, and particularly subscribe to FITSNews.com, where we will continue the push for truth and accountability here in the Palmetto State and beyond. We'll catch you next week.